for this, and I really hope that today's discussion takes us a step further to resolving some of these issues we've discussed today.
Rob Roberts. Thank you, Mr Holloway, for calling me in this important and solemn debate. A pleasure to serve under your chairmanship once again, and indeed to follow the Honourable Member for Bristol East. I have to commend my constituency neighbour, the Member for Allen and Deeside, for securing this debate on such a vital issue for our Flintshire community. I'll also take this opportunity to butter him up a little bit and welcome the Minister to his portfolio, and feel sure that he is the right person in the right role at the right time to drive this forward and obtain the justice that this family and families across the country deserve. Mr Holloway, crime is one of those things that will always exist in communities. Whatever we do in society and whatever laws we pass in this place, there will always be various crimes of varying degrees of severity. And rarely, and thankfully it is rarely, there's a crime that the headline writers say has rocked the community. In August of last year, the Deeside and wider Flintshire community was rocked. This is North East Wales. This type of thing doesn't happen in our communities. And the words we use in this place to debate things are important. Erskine May tells us that moderate language is of utmost importance in parliamentary discourse, so I always do my best to keep within the boundaries of that principle, and I try to avoid extremes like evil and hate. When Russell Marsh, and for the record, that'll be the last time I do him the courtesy of using his name in this speech, when he killed Jade Ward, the egregious act at her home in Shotton, the nature of his crime could quite easily and fairly be described as evil. In the aftermath of that horrific event, Jade's friends, family, and indeed our entire community could certainly be justified in having feelings of hate. It's fair to commend both the North Wales Police and the court system for bringing him to justice, as he was handed a minimum 25-year sentence in April earlier this year. With all the delays and issues that we hear about in our justice system, it was only 7 months for the whole investigation and trial and sentencing. And look, I say 7 months, a lifetime, no doubt, for Jade's family and friends. But justice was served and seen to be served swiftly. But was it? Of course, seeing this vile wretch of a human carted off for at least 25 years is justice in one respect, but a lingering problem remains. And it's this lingering problem that we must address. And it's at this point, Mr Holloway, I must commend Mr Duggan, the family friend who set up this petition. I'm not sure whether he's aware, but it obtained signatures from every single one of the 650 constituencies in the UK, from the far reaches of Orkney and Shetland off the north coast of Scotland down to St Ives in the south of England, on its way to more than 130,000 signatures, including 2,808 of my constituency in Delhi. And considering that Delhi's numbers for national petitions are normally in the low teens, it's a great indication of the depth of feeling in our community about the issue. Jade's sons are now in the loving care of her family. I don't think there's a single person among us, Mr Holloway, who can comprehend not only having to attend the funeral of your child, as Jade's parents had to, but to have to somehow hold everything together in the aftermath to provide a stable, loving home for your grandchildren as well. Compound the difficulties of being faced by the nature of the crime itself with the fact that the perpetrator has rights. We hear a lot about rights in this building, and how one person's rights are being infringed in favour of someone else's rights. In this case, the perpetrator's rights are being held as in some way having any relevance whatsoever. He has to be consulted, he can take decisions about where the children live, go on holiday, where they attend school, be kept up to date on their progress. Just to be clear, we take away parental responsibility in cases of serious neglect. We take away parental responsibility in cases of serious cruelty. What more neglectful action could there be than depriving 4 children of their mother? What more cruelty would we need to see than taking a young lady and murdering her in a brutal and vicious way while her children slept in their bedrooms next door? I read the government's response to the petition when it passed 10,000 signatures. And I echo the comments made by the chair of the Petitions Committee, the Honourable Member for Newcastle upon Tyne North, in expressing my disappointment with that response. I appreciate the sentiment that we already have means to take these steps in existing law. But as has already been mentioned several times, it's time-consuming, it's expensive, and puts more strain on an already impossible situation for the family to deal with. In the case in 2013, where parental responsibility was terminated because the father had been convicted of violently attacking the mother, it took years to terminate his rights on something that would have been obvious to anyone with a modicum of common sense about them. In this case, we're talking about a violent murder. This should be an absolute no-brainer that the perpetrator should forfeit his parental rights immediately when convicted of the horrific crime. There can be no greater cruelty. He should play no further part in the lives of these children. And Mr. Hollivone, if I had my way, he'd play no further part in society for the remainder of his natural life, as 25 years should really have been a whole life sentence for what he did. And people might think, you know, this must be something that happens so rarely in society. So I did a bit of digging. The House of Commons Library tells me that there were 542 homicides, murders, recorded in England and Wales in the 2020/21 fiscal year. In 414 of those cases, the relationship between victim and offender is known, and of those, 67 cases were recorded as being partner or ex-partner. So assuming that figure carries through to the others where we don't know the relationship, that's 87 murders per year between partners or ex-partners where children may exist. And just to be clear for the record, this isn't the number of confirmed cases where parental responsibility is a factor, just an estimate of the number of cases where it might be. Potentially 87 cases a year where the nightmare of a murder is compounded by the additional cruelty of the perpetrator controlling the lives of the children from prison. It's absolutely unconscionable. But the statistics don't matter. I've been making all the same arguments if it was one family or 10,000. The law currently leaves the status quo to persist unless a long and laborious process is carried out to change it. It simply requires a switch of priorities. Put the burden, as the Right Honourable Member said earlier on, put the burden back on the murderer. If found guilty, make the suspension of parental rights automatic at the date of conviction and make him fight to get it back, not make the family fight to block him. Social services and the local authorities will already have been intrinsically involved by that point, as it will inevitably be months down the line between offence and conviction, and the children will already be in the care of the remaining family or a suitable foster placement where appropriate. The law simply needs to change to give social services the power that it would have if, for example, both parents had died. Come back to the opening words of my speech. I tried to avoid extremes of language. In cases like this, though, where one parent has unlawfully killed another, the perpetrator should, for the purposes of parental responsibility, be counted as having died as well. Seems, Mr. Hollivone, to be a complete no-brainer. Rather than putting the family through a horrendous process of trying to get parental responsibility removed, re-victimising them and keeping a killer in their lives, we should automatically just remove the perpetrator. We need to bear in mind that according to the Sentencing Council, the starting point for the minimum time to be served in prison for an adult guilty of murder ranges from 15 to 30 years before taking into account any aggravating or mitigating factors. Assuming reasonably that in the vast majority of cases there will therefore be a minimum of 15 years in prison. And by that time, most children are likely to be over the age of 18. I don't see any reason not to say that the parental rights should be taken away at conviction and never restored, unless there's a specific and significant reason to do so. My right honourable friend can work out what specific and significant might mean, but we shall leave that up to the law writers. But should the children then, upon reaching adulthood, decide that they want to have contact with the perpetrator, then of course that remains their right, because there'll no longer be an element of control over their lives. So in closing, Mr Hollowburn, the families of victims have suffered enough. There's no reason to prolong their suffering. I hear the comments of my honourable friend from Wrexham earlier with some of the potential pitfalls that may occur with things like this, and this is one of those occasions where the unintended consequences can have wide-ranging implications. We do need to keep in mind the best wishes, the best interests of the children as paramount every time. That said, I believe this is a simple change, steeped in common sense, that could be made with a relatively short bill, and I implore the Minister to make it happen with all due speed.